Hello, classmates. My name is Joseph Keefe. I'm here to explain how GINA, HIPAA, Stark Law, resource allocation, and medical malpractice, on how these different laws can affect us and the patients for our own protection. So I just wanted to, as I go along with this presentation, I will go into detail about how these different laws work and what their roles are for us when these laws are implied. Okay, classmates, let's start with Health Insurance Portability Accountability Act. It was an act that was put into law in 1996. So what this law does, it's a federal law that sets rules for healthcare providers and health insurance companies about who can look at our health information. This law gives the patient's rights over our health information, including the right of the copy to be received by the patient who looked at their health information. Um, Patients have the right to decide who can receive the information. They have the right on who they get to share the information with. But the only way this patient information can be shared is between doctors or nurses, only to benefit the patient on the best of care that they think that may help the patient to get treated. So it's okay between the doctors to share information that's helping the patient on the case. Now, also, this information can be requested through the law, and that's the only way that the information can be released is through the law if it's requested. But the patients have the right to decide whether or not who received this information. A third party cannot request this information without consent from the patient, which would be against the law, and also can lead into courtroom allegations and lawsuit of the facility like Serenity Hospital will be liable for that and will also um, get sued for that. So it's better to be careful and not share information with anybody else if you have information on your patients, unless it's within your staff that's helping the patient. GINA, which stands for Genetic Information Non-Discrimination Act, and this act was enacted in 2008. And what this law does, what GINA does, is protect our genetic information from being shared with other parties without consent, and also people that have previous patients that have previous illnesses, if they were looking to have like a policy, a health insurance policy with like Blue Shield or Medi-Cal, Medicare, and if they have any existing chronic illnesses or anything like that, this law prevents health insurers from discriminating patients from receiving coverage just because they have a pre-existing health condition. And also, this law ties into HIPAA to protect our rights from underwriting procedures, and also protect our protect us from not having to submit a genetic test to other parties. This law is based off of 5 categories, which is built on HIPAA protection, additional underwriting protections, prohibits requiring genetic testing, restricts collections of genetic information, other protections. GINA expands the genetic information protection included into the Health Insurance Portability Accountability Act of 1996. In other words, this HIPAA prevents a plan or issuer from imposing a pre-existing condition and exclusion provision based solely on genetic information, and prohibits discrimination in individual eligibility, benefits, or premium based on any health factor. In other words, GINA is to protect our rights of genetics from being shared with other parties, as I mentioned earlier. So, and it also keeps us from being denied based on our family history. Medical malpractice is tied into a tort law, and tort law is a civil wrong, and from one person doing harm to another person. Um, for example, a patient, and for example, a physician provided not the correct form of care to the patient, and the patient was harmed by it. So this will turn into medical malpractice for the doctor not performing properly on the procedures that he performed on the patient. Consequences of that is prison time. Doctor will face criminal charges, get fined, and also lose their license because they took an oath to protect the patient. And also the facility at Serenity Hospital will also get sued because we're responsible for the person that we hired. So we'll also lose commodities for that, for the mistake that just occurred between the physician that we hired and the patient that received care from us. Stark law. Stark law governs physicians' referrals, which makes self-referrals illegal for physicians. In the past, some doctors would send patients to other businesses referred by them, and also to receive extra money for referring the patient to certain facilities that was referred through them. So the Stark law kind of prevents that from happening because the facility will lose a lot of money. Well, the insurance companies will lose money for doctors self by their own self referral, and that can also turn into a lawsuit as well if the patient hasn't actually went to the facility. So that was a lot of that was occurred a lot in the past. So now Stark law has pretty much stopped that from happening. The Quiet Time Act, the Quiet Time actions allow private citizens either suing either individually or even through the state to bring legal actions against people who break the law. When quiet time is in use, that person is able to receive a portion of the damages and the rest will be retrieved by the state. As for the anti-kickback statute, which makes the person willingly know that this is a criminally offense against them and to willfully offer, pay, or to induce or award referrals of items reimbursable by a federal health program. Cultural competency. In today's healthcare, we have different groups of people who come from everywhere in the world. So when we have patients, it is important not to judge a patient by race nor employee by race. I will not tolerate that at Serenity Hospital because we're all one race and we're human, and it should always be a diverse of different cultures working with people, and it should never be about race when coming to work. Um, by having different cultures in the Serenity Hospital, this creates patients' trust and comfort to talk about certain things, maybe your religion or uh, their history and language, because not everybody can speak the same language as everybody else. So this generates a comfort. So cultural competency should be uh, implied, and also employees should also be trained about cultural competency because this is extremely important in the healthcare profession because we have different people coming to receive care and from all over the world, and it should not be any discrimination towards anyone.